Right, welcome back. We're doing part two where we look at the Employment Rights Act, and I'm once again joined by the fabulous, the amazing Joanna Sutton from Knockholds. How are you doing?
Good, what an intro, thank you.
Oh, no, from the bottom of my heart, you always give us so much time, energy, knowledge, and I think it's crucial. I think it's really important. I know I've got a lot of clients who are nervous about this stuff, and just being able to listen to someone who knows what they're talking about, talks about it in plain English, and just makes it nice and clear. It's gold dust. So thank you.
Oh, you're very welcome, thank you.
Alrighty, look, let's get right into it. So last time we went through the different parts of the Act that were coming in April, and we deliberately kind of stopped it so that we could think about within this part October onwards and also kind of 2027. I can't believe it's 2026, to be honest. I still can't get my head around that. Where did
No,
last year go?
it disappeared. I don't
No,
know where it went.
look, I literally up and I'm like, well, how am I writing 2026? Anywho, so last time we did the changes that were coming in April 2026. This time round we'll do October 26 and then we'll look at 2027 as well, particularly because there's at least one biggie coming in 2027. So
There
let's
is.
start off with yes, the one that we're all like, but we shall get there shortly. So let's start
Mhm.
off with fire and rehire. So October 2026, fire and rehire becomes automatically unfair dismissal, which I'm quite pleased about, to be honest. What does that mean that people won't be able to use it at all? Because that's quite specific, isn't it? Saying it'll become automatically
Mm.
unfair dismissal. So is it going away completely?
That was the original intention of the government, I think, where they basically wanted to outlaw it. So, this practice of fire and rehire is basically used where an employer wants to change an employee's terms and conditions, so the terms of their contracts. Normally, you have to get the employee's agreement to that. So, you would consult with the employee, explain to them why you want to change it, what the changes mean. And then, if the employee still doesn't agree, then you either have to decide to just carry on with the existing contract, or if you want to force it through, you can. Or one option is you dismiss them, and then you offer them new employment on the revised terms that you wanted to try and force through, or you give those terms to somebody else and you get rid of the employee. So you fire and rehire. And again, over the last few years, that's become a bit of a controversial practice. Again, P&O ferries are to blame, I think, for this one, because that's what they wanted to do. They made all their staff redundant, then wanted to rehire agency workers who were cheaper. And so it's been used then. It also, I think Tesco used it, where they were trying to overturn a deal that had been negotiated previously with unions, and then they decided they didn't like that anymore. So they were trying to force it out and use this practice. So again, big employers forcing through changes because the balance of power between, big corporation and individual employees is completely out of whack. So the government said, no, we don't like that. We want to outlaw it, basically, so that their intention was that you couldn't use it at all, unless it meant that the company would go under, essentially, if you
Mhm.
didn't enforce the change. And it was one of the things going through the ping pong stages in Parliament where the Conservative and Labour government and the House of Commons and the House of Lords just couldn't agree. So where we've got to now is that you can't force through these changes by using fire and rehire, um, if it is a restricted variation. So there are certain things that they are specifying you cannot change by going through this process. So it's obvious stuff like you can't change hours and salary and holiday and things like that. So the big things that are sort of fundamental terms, and that exception about the company going under or being in sort of serious financial difficulty if the change doesn't go through is still there.
Yeah.
So it's not something that that's used every day, but it is something that politically has become quite unpopular. So again, it's really just to sort of to earmark that, to say we don't like this practice, please don't use it unless you absolutely have to, is
Mm.
basically the stance, I think.
I have to say it's always been one of those ones that's just never really sat right with me. So obviously when I'm advising, clients or when I'm working in businesses, I'll always say like these are your options and this is one of them, but I really wouldn't recommend that you do
Don't do
it.
that one.
Like just I'm doing my job by telling you, but I really wouldn't recommend that you do it. 'Cause it just doesn't sit
Yeah.
I am pleased to see something kind of making that a little bit more stringent, which is really cool.
Yeah. Yeah.
Okay. So we're sticking with October. We've not got too much happening in October. April was quite a busy month from the
Mhm.
last podcast that we did.
Yeah.
Um, this time we're looking at third-party harassment liability. So October 26th, it will see employers become liable for third-party harassment. So that's customers, clients, contractors. Why is this such a big shift?
Yeah, I mean, this is a big one, and it's one
Mm.
that a lot of employers are concerned about. So, I mean, it's big in the sense, and it goes back to what we were saying in the first part of the podcast about harassment really being a big part of the government's agenda. To make sure that this is being dealt with, and that there is a cultural change within organisations, that these things are no longer sort of um, people don't look the other way, in the way that maybe you did in 30 years ago, that no one goes to work to be harassed. And this third party harassment was actually law, I think back in 2013 it was repealed. Um, basically what it means is that currently your staff cannot harass one another. So employees are not allowed to harass each other. That results in a claim. What this is doing is meaning that third parties also can't harass your staff at work. So as you said, clients or customers, things like that, which is much more difficult for an employer to manage than it is their own staff. So you have visibility of your own staff, you can train them, you can have clear policies on what they can and can't do. You can't do that for your clients necessarily. So what it would mean is perhaps putting something in your terms and conditions to say, oh, and by the way, we don't accept harassment of our staff, you must not harass any of our
Mhm,
staff.
mhm.
Makes sense, common sense. You would think that you don't
Yep.
need to spell that out. But if you think about perhaps a hospitality setting or something like that, like a restaurant, and you will have your staff dealing with members of the public, being waiters and waitresses, it's really difficult to police that in those circumstances. And the liability for those organisations, if employees can bring claims for customers in that setting, harassing them, where the employer has no idea it's happening and no ability to control it, is
Mhm.
really, yeah, really difficult. So this is a big change, and one
Mm.
that employers in those sorts of settings are very concerned about. And
Yeah.
it's not just sexual harassment, it's harassment for any protected characteristic. So age, sex, race, disability, all of those things. Um, so yeah, it creates a huge new area of liability for employers.
And look, I would like to think that everybody in the world would agree with me, but harassment in any way, shape, or form is not okay. So fabulous to see things that kind of bolster that, and as much as we're seeing with this. But I guess my concern is, as an employer, how am I supposed to stop someone that is not under my control, customers in particular? We all know what it's like when you go to a restaurant, not okay, but when you go to a
Mm,
restaurant and it's horrible. As an employer, how am I controlling that? And then also, how am I liable for that? It almost feels
mm,
as needs to be legislation that covers the way the customer's acting, but not necessarily the employer being liable for it. I suppose, unless it's a case of the employers tolerating it and kind of letting it happen, I can see
yeah.
that being liable for the actions of someone that I have no control over. That feels like a lot.
Yeah. And I think that's where it comes down to how the employer approaches these kind of complaints. So
Mm,
it will be important to make sure that staff are trained on what is and is not acceptable, what to
mm,
do if they are experiencing harassment. So in a restaurant setting, they're waiting a table, someone says something. There's a supervisor or a manager that they go and report it to, and it's dealt with. Like you say, is not just
mm,
accepted and turned a
mm,
blind eye, or get someone else to go and deal with that table.
mm,
It's that kind of thing. So I think that training around it, having a policy, having a clear reporting process is going to be really important for employers
mm,
to be compliant with this obligation. But if you think about it in a different setting, I don't know, if you have your largest client who is sexually harassing a member of staff,
Mhm.
that potentially causes huge financial loss to the organization for reprimanding that client, and losing their business. But that is what is expected
Mm.
to happen, and
Yeah,
you know rightly so.
it should. Yeah, completely agree. Yeah. Okay. Sticking with October, and then we've got tribunal time limits doubling. Hey.
Yeah.
How do we feel about this one? So where are we now in terms of tribunal time limits, and how's the doubling significant, and does it increase legal exposure for employers?
Yeah, so again, this goes back to what we were speaking about in our first part of the podcast about the current strain on
Mm.
the employment tribunal system, unfortunately. So, currently, the deadline that you have to issue a claim, if you want to, is 3 months from whenever the thing has happened that you are complaining about. So, 3 months from the date that you got dismissed, 3 months from when you were discriminated against, that kind of thing. And it's a pretty short time limit, that can go pretty quickly. So what is being proposed now is, as you say, that will double, so you will have 6 months to bring a claim, which, you know in the grand scheme of the deadlines that you have to bring other types of claims outside of employment law, so for breach of contract, for example, in the civil cause, you have 6 years. So yeah, yeah, so you know 6 months in the in that sense
Mm.
seems, still like quite a short period of time. Um but I think the intention behind that is to reflect the fact that 3 months is really short, and if you have somebody who perhaps has a claim as a result of maternity or pregnancy discrimination, and they have just had a baby, that 3 month period is just gone in the blink of an eye. And so by
Mm.
extending it to 6 months, again, is meant to be making sure that everybody has access to justice, and proper time to put a case together, or to seek legal advice, or to take things further when they feel ready to do so, rather than, a lot of people don't even know about this deadline. They think about things for a while and then think, oh, I'd like to think I'll see if I can do something about that, and they're out of time.
Yeah, do you know what? I feel like I know last time we were talking about how some of the things in this act, it just feels like we're tidying up things that just don't quite feel, well, never quite felt right. I think this is definitely one of them. I think part of the problem with tribunal time limits at the moment, which you kind of alluded to, is I don't think people know about them. So, like you
Mm,
say, people think about stuff and then they think, oh, okay, well, it's been a few months afterwards, I want to do something, and then, as you say, they're timed out. And also, bringing something to a tribunal is a big deal. Like, you
yeah.
kind of need the space and the time to digest that, understand the process, figure out if it's the right thing for you. And 3 months
Mhm.
doesn't kind of sit right. So this, to me, feels like a common sense change. I think it's going to be frustrating for employers because normally, you've got that, we're counting down, aren't we? And it means that we're increasing that time. But ultimately, I suppose the thing is, if you're doing things in the correct way in the first place, then you haven't really got to worry about this stuff, have you?
No,
Um,
exactly. And I think that actually that kind of classic, you would sort of count the time to see after
mm,
someone had left you. If you were expecting that they might take it forward, you'd kind of be like, okay, 3 months' time, we don't need to
yeah.
worry about that. In reality, because of the pressures on the employment tribunal, that's not happening.
Mm,
That time you can get a claim months later, out of the blue. So yeah, so that doesn't happen necessarily anymore anyway. But yeah, I
mm,
mean, I think that it makes sense. And equally, it might be that that means people have more time to take legal advice, or actually they have more time where their life moves on. I mean, in my
mm,
experience, people are very angry when things first happen or they feel wronged, but then you go and get another job, or
yeah.
something else happens, and in a few months time you don't feel so strongly about it. And so that it
Mm,
may have that beneficial effect as well, that actually,
mhm.
you know that they don't necessarily result in more claims, although I think that the impact assessment is that it probably will result in an increase.
Yeah, no, I agree. But then you've also got that compounding issue in terms of the resourcing within the tribunal system anyway.
Mhm.
So it feels we're kind of going round in circles a little bit in terms of,
Yeah,
yes, a longer time to bring something, but it doesn't, you're not going to have it heard sooner because we haven't got the resources. That's the problem.
exactly. No, exactly.
So one step forward, one step back, but I feel like it's positive.
Yeah, I think so. I think so. I think that yeah, it's not a huge in the as I say in the grand scheme of things, it's not still not a huge time limit. It's not like it's years and years.
Okay. Alrighty. So that kind of sees us out to the end of 2026, and it brings us to the biggie, the showstopper in 2027. So, for those of you who haven't been kind of following what's happening with this act, we're now talking about kind of how unfair dismissal is going to change. And for me, this is the biggie, right? This is the one that I think is going to impact a lot of employers and a lot of employees, really. So tell us a little bit about what I'm talking about. Why is this change with unfair dismissal such a big deal?
Yeah. So currently, you have to work for your employer for at least 2 years before you can gain the right to claim unfair dismissal. So, up until that point, you can be dismissed at any point for any reason without following a process, and there's nothing you can do about it unless you have other claims for discrimination or whistleblowing and that kind of thing. And that's a really long time, 2 years, to work for someone and have really no employment rights. And so the Labour government, this was like top of the agenda. This was one of their flagship things that they said through their campaigning in the election for them to be in power, that they said, we're going to abolish that and we're going to make it a day one right, so that from your very first day of employment, if you're dismissed, then you will have the ability to claim unfair dismissal. Obviously, hugely unpopular with businesses. And so there had then been, when the bill was introduced into Parliament, a very complicated arrangement where they said there would be an initial period of employment during which they would have to follow a lighter touch procedure, and no one really knew what any of that meant. It sounded a bit like a probation period, but no one was really sure. It was going to be a 9-month period, which just seemed bizarre. Anyway, so when this was going through Parliament, that was heavily opposed because it just made things really complicated. And so then someone cleverly in the House of Lords said, why don't we just have a 6-month period where you have to have worked for your employer for at least 6 months instead of 2 years, and then everyone knows where they stand. Um, and so actually, I think great idea. That makes it much more straightforward. And so, yeah, now you will have to have worked from January. We think it's going to be January 2027. You have to have worked for your employer for at least 6 months before you can claim unfair dismissal. So that's where we've landed. So that is expected to mean, I think the stats are that about 6 million more employees will gain the right to claim unfair dismissal, which employers don't like. It will be much more popular for employees. So when I have employees coming to me and saying, I've been sacked and I've worked for my employer for, nearly 2 years, what can I do about it? And I say nothing. It, that is doesn't give anyone protection, job security, anything at all. So 6 months seems like a reasonable period to me. It aligns with what a lot of probation periods are already. And really within 6 months, you'll know whether someone is right for you, the role that you've employed them for, the right person for your business. So I think it makes sense. I don't know what you think.
I think, I know we've talked about it a lot where this is kind of, the act kind of tidies up some of the kind of niggly things that we have in terms of employment law. Yeah, it feels fair because I feel like the 2 year period, whilst it's definitely been something that I know kind of clients and employers have relied on in the past, it never quite felt right because it felt like too long a period of time. Whereas 6 months, I think, probably does feel just about right. And also, and it's my own personal opinion, caveated, but usually people can kind of have a bit of a mask on and pretend to be what you want them to be for about a period of 3 months. People can't usually last, 4 to 6 months of pretending to be something
Yeah.
that they're not. So, provided you've got like a clear probationary period, I think if it ties in with this, I think that makes sense. It just means, from my perspective, that employers need to get much better at dealing with problems because I'm sure you see it every day in your line of work, but people will come to me and say, oh, Trish, we've had this person and they've been underperforming for the last 3 years. And I'm like, well, why haven't we done something about that sooner? Oh, it was just easier to leave it. We didn't want to upset the apple cart. That kind
Yeah.
of thinking just isn't going to be okay anymore, or at least it will be okay. But what you're able to do about it from a legal perspective is going to be very, very different. So
Mhm.
I think it's a good thing. I think it pushes people to deal with things sooner. And you know, when I think about those kind of scenarios, if you've had somebody that's in an organisation underperforming for years, they're probably not happy either. Do you know what I mean?
Yeah.
Unless
Yeah.
they're probably unaware, they're probably unhappy. So I think things like this will probably help from a practical perspective to deal with that kind of stuff. But I guess only time will tell. We'll have to see. And you said January, so we're not going for the April, October with this particular thing.
Yeah, I think because they have now reached this certainty about the 6 month thing, and one of the other things that was agreed to kind of get it through was that they would remove. There's currently a cap on how much compensation you can recover for an an unfair dismissal claim, which is either a year's salary or a cap that the government increase every year, which at the moment is about 118,000. So your annual salary, if it's lower, or that as a maximum. Um, and they decided that they would abolish that. And so, as part of that, they're now saying, yeah, it's going to all come in January 2027. What it some commentators are saying is that they think that actually this might make employment tribunal claims slightly more straightforward, because what we see at the moment, because of that 2 year time limit, when employees realize that they haven't got the required length of service to be able to bring an unfair dismissal claim, and you say, oh, but you could bring a discrimination claim, have there been any issues in respect of that, they try and kind of sometimes shoehorn a claim into, oh yeah, I think, yeah, there was some discrimination because this, that and the other. Discrimination claims and whistleblowing claims, the employment tribunal automatically classes more complicated and
Mhm.
need at least a hearing of 2 or more days, which then clogs up the system, leads to, increases all these delays. Whereas unfair dismissal claims, they class as more straightforward and can be dealt with within a day. So potentially it could mean that, yeah, the claims go back to being about what they're actually about. I think it wasn't right that I was dismissed, and bringing a claim on that basis.
Okay, and that would be good, wouldn't it? Provide a little bit more kind of closure for
Yeah,
people quickly, hopefully. Fingers
yeah.
crossed.
But I think, as you say, managing having probation periods and managing them is going to be so important to this, because so often people want to avoid having the difficult conversations. They never, bring up performance issues or conduct concerns that should be dealt with. So I think, having sort of a probation period in place with regular review points and properly documenting if there are concerns or issues or more training required, that's then, put in an email, so that then when you get to the point, if it's not going to be that that person's employee is not going to continue, it's not a shock to them. You've already had, various conversations, you've told them what the concerns are, which will then hopefully reduce the risk of them wanting to bring a claim, because you have laid the groundwork. So that is going to be absolutely key to this. And again, manager training and everything else, so that they're doing all these things and they understand the reasons why, rather than it just being, another thing they've got to do, or sort of admin. Probation is not going to be an admin thing anymore. It's going to be really important to help defend claims for unfair dismissal.
I think you make a really important point about communication there, because I would say pretty much all of the work that I do when I'm fixing a problem is a miscommunication. It's somebody hasn't understood or something hasn't been communicated, which has then led somebody to feel a certain type of way, which in a lot of times is, very valid. That
Mm.
communication piece is so important, and particularly tied in with this point in terms of people understanding where they're at. Because what I tend to find when things go wrong with probationary periods is just the employee's got no clue. They haven't, or that either they haven't been reading the signals from the employer, or the signals haven't been clear enough. So I think that's really, really important for people to remember there about getting across clear messages within the right timescales.
Yeah, absolutely. And yeah, dealing with the right things, which is, maybe that's a conversation for another day.
I feel like that's a whole other podcast.
It is.
Just
There we
on
go.
that.
We'll schedule that one in.
Alrighty, look, we'll stick with 2027 because we're almost there actually. I feel like there was a lot less
Hmm.
in 2027.
Yeah.
So we've also got changes to 0 hours contracts. I know we've talked about this quite a lot before. Um,
Mm-hmm.
so what's happening here? So I know what they're trying to do is bring a bit more kind of predictability, a bit more security. So how are
Mm.
things going to change in 2027? Are we getting rid of 0 hours contracts, or is it just that things are going to be kind of strengthened a little bit more in terms of how they work?
Yeah, so again, this is another, I wouldn't say a U-turn, but a definite softening on what the government had initially, or the Labour Party had initially said they wanted to do. So initially they were saying they were going to ban exploitative 0 hours
Mm.
contracts, and they politically were very unpopular. And that has been watered down somewhat. We spoke about this on a previous podcast in terms of what was being proposed, and unfortunately, is still really complicated. I think this is the worst bit of the Employment Rights Act in terms of what's proposed here, which will mean that there need to be lots of regulations in place to actually bring it into force. So lots more kind of detail to come. But essentially, the headlines of what's being proposed is that. You can still have 0 hour contracts, so they can still be used, but there will be sort of additional rights relating to them. So, for example, an employee will have the right to be offered a guaranteed hours contract where they are regularly working a certain number of hours, per week, and that's going to be looking back over a previous 12-week period. So if you were on a 0 hour contract, or you were on a contract for a low number of hours, but you're regularly working, say, 20 hours a week, an employer will have to say, okay, now you're regularly working 20 hours, we're going to offer you a contract for 20 hours. And so they have to do that. And at the moment, it looks like you will have to do that every 12 weeks. So the admin burden there is awful, for employers who kind of use these types of arrangements. So that bit is going to be quite difficult to manage. The other bit that is being imposed, that you have to give reasonable notice of shifts, and you have to be compensated for shifts that are cancelled or cut short, at the last, without good notice. Again, going back to kind of what we've said about a lot of these changes makes sense. That should be how people are notified of, that when they're required to work. And again, that's meant to provide more security and stability, and mean that people can plan their lives and their caring responsibilities and everything else. So that bit isn't as bad, but it's the guaranteed hours, which it has been really controversial, unpopular, what is proposed, because some people are saying, look, actually 0 hour contracts work really well for me. I'm a student and I like the flexibility, or I've got my own business and I don't mind working like this, or I'm retired. But equally, there are businesses who use them for seasonal work and things like that. And so there had been, when the bill was going through Parliament, quite a lot of discussions around, should there be an exclusion for seasonal workers, like people picking fruit crops, or manning ice cream stands in the summer or whatever. But that hasn't been carried through. So again, we need more regulations on this. There will be further consultations on this, but yeah, it's admin heavy, and so it will really rely on having good systems in place to track the shifts that are being worked, so that you can check the guaranteed hour requirement, but also where they're being cut short or changed. Employers potentially will need to change their normal practices to accommodate whatever these new rules are about what that reasonable notice will need to be to make any changes.
I feel like 0 hours contracts really kind of divide opinion. So I'm a big fan of TikTok, so I do a lot of TikTok videos. Whenever I do one on 0 hours, I get a real kind of divide in terms of, you were alluding to it earlier. Some people absolutely love them and they just really fit around their work life. They're obviously being treated fairly and looked after
Yeah,
well whilst doing it.
yeah,
Other people absolutely hate them and that they're the worst thing in the world. So I always find there's never anybody in between.
no,
It's either the spectrum or that end of the spectrum. So
yeah,
yeah, I definitely
proper
agree that we
marmite.
Yeah, I definitely agree that we need more reforms around it, but I think, I don't know, I felt like when they were starting to talk about exploitative zero hours contracts, it almost kind of demonized it, when
Mm.
actually there's quite a lot of people that do like them. It's just as with anything, there are organisations that don't use them in a fair way. I suppose it's kind of
Hmm.
finding that balance so that people can still use them, but not alienating the people that like them, because it seems like there's quite a lot of people that like them. I was surprised.
Yeah, exactly. And I think, going back to that point about the whole intention behind this is to sort of recognize modern working practices. Well,
Mm,
that is a modern working practice, what with that and the gig economy and everything else,
mm,
people didn't work like this 20 years ago, but, we do now.
mhm,
And so I think it's intended to sort of build a bit more regulation around it. And whether it changes, so one of the suggestions had been instead of employers having to offer the guaranteed hours, it could just be a right for an employee to request it.
mm,
That then gives that flexibility of people who are like, no, I'm fine. I like this
mm,
arrangement. I don't want to change it. So I wouldn't be surprised if we see some changes to what's currently proposed, particularly as this is kind of one of the later
yeah.
changes that we're looking out for. That, yeah, it might be that we don't end up this coming in the form it looks like right now.
My hunch is they've put the things later on where they think they're going to be a little bit. There's going to be a little bit of change. Obviously, don't know that, but it just gives
Yeah,
more scope, doesn't it, to be able to shape things and more time. That
yeah,
would be my.
definitely. The ones that are more complicated, I think they've definitely kicked the can down the road a bit.
And then the last one that we've got for 2027 is around menopause. So this one is mandatory menopause action plans. Um, Tell us a little bit about that. What when we're saying mandatory, what do we mean? What is a menopause action plan? Tell us a little bit more.
Yeah, so I mean, this one is again, I think meant to reflect modern working practices.
Mm,
Um, Essentially, what it is that large employers, so employers with more than 250 employees, will be required to put together an equality action plan. So it is then required to provide information about prescribed things, which at the moment, all that has been prescribed is gender pay and menopause. So essentially, what employers are doing within their organisations to address those two areas. And the policy intent behind it, I think, is definitely to do with the gender pay gap because large employers over 250 employees have been required to report their gender pay gap for some time.
mm,
And sometimes what they're doing is reporting it, but actually then they don't have an action plan in terms of what's being done. And so the government have said actually they think the gender pay gap is not closing as quickly as they would like. It's sitting at around 13-14%. And so they want more proactive steps to be taken to deal with it. So menopause then links quite closely to that because I think the stats are that 1 in 10 women who are going through the menopause leave work because of the symptoms that they're experiencing. So that is then resulting in the more senior employees who would be being paid more, leaving the workforce, which is then having an impact on the gender pay gap. But also, you're losing some really great, talent and experience
mm,
within your organisations, and people are working later. So again, just reflects the reality of, I think, normal working life and these things. Being something that employers are having to deal with and that people are speaking about more within, the organization and having to deal with. So I think that makes sense. I think the fact that they've said prescribed matters relating to equality is interesting and it leaves it open for other things. I know that certainly when this was going through Parliament, there was a debate around whether menstruation should be included as well. What are you doing to support women who have conditions like endometriosis or PMDD and that kind of thing, which they haven't included at the moment. But I think potentially the way it's worded, it leaves it open that that could be potentially broadened. And we also then have the proposal for disability and ethnicity pay gap reporting to come into force as well. It's not part of the Employment Rights Act, but it's something that's been kind of
Mm.
going on in the background. So yeah, you can see that all of these things are meant to be sort of enforcing positive change to do with equality, which you know the intention behind it is absolutely great and should be
Yeah,
happening.
yeah, we can't really argue with positive change around equality.
No,
And would
exactly.
all right, look, I think that's all of my questions. So we've done October 26 to the things that are coming in 27. Anything else that you think it's important for listeners and watchers to know?
No, I would just say keep a close eye on all of this
Mm,
because it is, yes, we have the Employment Rights Act that now, is in its final form, but there are lots of consultations ongoing that if businesses listening to this don't agree with some of the stuff we've said, this is your
mm,
chance to, to respond to those consultations and to shape how this is, how this is actually going to end up looking. I know that there's lots of, the equality action plans, for example. I've been working with a menopause charity who are speaking with the government about what they think needs to be, included in that. So there is lots of consultations and opportunities to get involved to shape it.
mm.
But certainly until it's in legally in force and each of these dates are kind of hit, then we don't know exactly what it will end up looking like. So keep a close eye on it. If you're unsure, Trish and I are more than happy to advise further on what the current status is and what you should be doing.
And if people want to get hold of you, how do they get hold of you? What's the best way?
Yeah, so always give me a call, drop me an email, send me a message on LinkedIn, anything like that. I'm always more than happy to to have a no obligation chat just to see how I can help. So yeah, feel free to reach out.
Amazing. Look, thank you so much for your time. I've learnt a lot today, so thank you. That's been really, really helpful because there were some bits that just didn't quite make sense, and you always make things make sense. So thank you. Thank you for your time and your brain. Really appreciate it. And hopefully, I'll see you again soon, and we can do more. I mean, hopefully, we're not going to get changes as big as this again. But as others come, we shall do more podcasts.
Absolutely, and I think as some of these come into effect, and actually employers start dealing with them, I think there's more to learn from that as well. So yeah, always happy to join you on your podcast, Trish. It's always
Oh,
really helpful for me too.
oh, amazing. Thank you so much. I'll let you go back to lawyering, and hopefully, we'll speak to you soon.
Thank you.